how the foster clause is separate from other clauses of the deed. So I'm trying to answer that sense or that because we're not consulted. No, it was because the consultation for the donor in terms of this particular slide, it was background. Not I caught indicated that the delay by the first in preparing and showing for Parliament must prepare and legislation that will bring about a comprehensive legal solution of the foster care. And we have indicated that in our previous meeting, but looking at the big entirety, we find that there are many not helpful identified, but we have identified helpful based age foster care solution. Otherwise, if we were to go out and look, also maybe, for example, corporal punishment and corporal punishment in a way being under the was if corporal punishment end up in the place they end up foster somewhere. So you say something like that also be bad, but you said no, let us look at the causes here are close present so that we can get this particular thing. And further than comprehensive solution, there was also a there must be necessary mechanisms which are also in terms of some of the provisions in the power functional some, and if those are not there in the legislation, power resources and required not necessary. So the bill was consulted, it was given 15 months that happened, and we are at this stage now. So basically now we have to look at summary of clauses that how as a team, yes, helpful that discussed clauses that are extracted directly itself, which this clauses provide a framework that address and identified circuit and normally they speak act provide quality of briefly, these clauses include the following. Initially, we had one and age, and then we put a following from, which is a decision about a balance. Rather than that, identified clauses 6 and 7, and we are saying these clauses and mechanism. Others more on the legal, others on and we also identified 24, which is guardianship, where we said extension of children's court assist getting addressed impact issues of adoption, as we also indicated, that adoption board should be adopted, but it's not a comprehensive. Oh, okay. Oh,
So okay.
James Curious, trying to find the sheet. It's a second meeting now.
cable.
Recording stopped.
Oh, okay. In the touch panel, on the touch panel. Okay. So I got. Yes, I touched it with the camera person. I selected. Yes. Okay. Where is it? I connect the HDMI hardware or onto the laptop. Wait, where is the HDMI cable? Where must I connect the HDMI cable into to my laptop? It's not a hardware, it's a software. Sorry. Just hold on. Okay. The person on the other side cannot communicate to you. Okay. On the okay, so I am coming to the camera. The Zoom camera. Sorry, hello. You want that? No, it's not a play. Because I want the meeting was already started when I arrived. Was being introduced to this. I am the audio and the camera, okay? I mean audio now. The audio is muted. Video calling, okay, sure. Okay. Remember Abrams. Mrs. Abrams? Oh, Miss Abrams,
Yes, Lindy.
can you hear us?
So I can hear you in the background, yes, and it sounds a lot better. It doesn't sound like it's cutting.
Okay, just hold on a bit.
Okay, thank you.
UGSD, can you hear us? Tulani? And Linton, can you hear us from your side?
Yes, Chair, we can hear you. Thanks very much.
Who I'm being promoted as a chairperson.
You have to start again, department. I'm sorry for that.
No problem.
In fact, you were just on the
Yes, right in the beginning.
slide.
Slide number 5.
Be close this, we cannot be close this.
Yes.
Okay, can you repeat yourself in terms of informing us how many clauses have you decided upon and out of the meeting that you had, the state law advisor, the parliamentary advisor, and the departmental advisor? Can you start there? Thank you. Over to you.
Okay, thank you, Honorable Chair, Honorable Members.
Recording in progress.
The agreement was that, yes, we decided on 12 clauses that will be extracted from the main bill, which form part of the foster care clauses that will, foster care bill that we'll be dealing with moving forward. There was consensus between all the advisors present at the meeting, and I was indicating that even the clauses that initially Parliament had identified, the state law advisor had identified, form part of the plans that the department had identified. So there are no new clauses that came in as additional in terms of that. But there were just new clauses in terms of interconnectedness that we had identified as we deliberated. That is clause 1A in the document that is before you, and clause 93 being a consequential clause, but it's not changing any position. That's part of the clauses that we need to look at. They are 12 in number, so the new bill, which we will be looking at later, will be having those 12 clauses. And we had indicated that the decision was taken based on the closeness or proximity of these particular clauses to foster care or to answering the court order itself. Not saying that some of the clauses that we have left out are completely not relevant in as far as foster care is concerned, but they are remotely connected and to those that are closely or directly linked at present for the purposes of processing this particular bill. And we are saying all these clauses, they seek to strengthen the comprehensive legal solution as ordered by the North Gauteng High Court. And these clauses include clause 1A, 1E, and 1H, which is the first clause that we looked at. And we also looked at clause 56 and also clause 57. And these two clauses, they look at putting structures and mechanisms in place in order to deal with foster care, because we understand that the court order itself has got two legs. It has got a comprehensive legal solution. It also has the requirement to put systems and processes in place in order to deal with the foster care. So these two are answering that part of the judgment of the order. And also the clause 24 is looking at the legal mechanisms relating to foster care. Clause 24 is looking at the issue of guardianship, which we'll discuss later, because we had said guardianship in terms of the jurisdiction of the children's courts. Let these courts, let the jurisdiction be extended so that at the end of the day, the matters relating to guardianship can be attended to in that particular court. Also, clause 85, issues of adoption, where we had said, yes, there are so many other areas related to adoption that would need to be dealt with, but for now, we are focusing on clause 85, and then the rest will be dealt with in the other bill. But for clause 85, it will fit for now for the purposes of this particular bill. And also clause 92, 93, which are looking at the cluster foster care. We also looked at clause 82, which talks to the determination of children who are at risk as children who are in need of care and protection, who at the end of the day will have to fall into the foster care system. We also looked at clauses 83 and 84, which relate to the decisions that have to be made in terms of the processes that have to ensue in the courts when the issues of determination whether the child is in need of care and protection and
issues of the court orders. And also the management of foster care orders in terms of clause 86, looking at the extension of foster care orders, read with section 48 of the Act, and also clause 94, which looks at the provision of, supervision of foster care placements. We have attached into this presentation Annexure A, which will be the face of the new bill that we'll be looking at, and also the updated metrics that speaks to the clauses that we are referring to, where we have given our response as a department in terms of how we feel with regard to the comments that have been solicited during public hearings by Parliament. Honorable members, in terms of clause 1E, we had said clause 1A would be speaking to the issue of abandonment, which we have taken into account. And now clause 1E will be looking at will contribute towards the comprehensive legal solution by minimizing the confusion regarding the responsibilities of the caregivers and being able to make a distinction from foster parents that are not in a foster care scheme. So in order to draw that distinction, which will assist in dealing with this. So it therefore streamlines the cluster foster care provisions, thus diversifying the foster care interventions. So that is the reason why we had to include 1E there. And then the definition of
mute.
Hello. Hello.
We can still hear you, Chairperson.
Okay. Who was talking and disturbing us? Okay. Carry on.
okay. Clause 1H.
1H, yes.
Right, 1H. Okay, clause 1H will also assist in terms of this bill by diversifying the foster care interventions and therefore contribute to the comprehensive legal solution as indicated. Further than that, Honorable Chair and Honorable Members, we've got clause 24, and we are saying in terms of this amendment, it will be another provision that will be looking at various forms of care for children. So it is important because the issues of abandonment are also dealt with in this particular clause. So it addresses the mechanisms that are required by caregivers to care for children that are orphaned or abandoned, which must be read with the 1A as we indicated initially. So these children may or may not necessarily require a foster care placement purely because they may require a legal mechanism to enable them to make decisions for children in need of care. So without this clause, we may not be able to deal with the comprehensive issue dealing with foster care. So that's why we included it, so that we can be empowered to do so. Further than that, it makes the legislative provision more accessible, serving the best interest of the child at the end of the day. The next clause, Honorable Chair, is clause 56. This particular clause, Honorable Chair, in conjunction with clause 77, it seeks to put a control mechanism to ensure that the required standard for provision of child protection services is achieved, because the whole concept of foster care is part of the child protection service. So it needs to be dealt with in that particular fashion, so that we provide for a comprehensive legal solution at the end of the day. So it will contribute to a legislative response to a challenge relating to foster care as required in terms of the structures for the desirable child protection system. So it is a required mechanism which also responds to the second leg of the judgment. So it responds to the mechanisms that need to be put in place so that at the end of the day, we achieve the comprehensive legal solution to foster care. Clause 77, Honorable Chair and Honorable Members, seeks to address the systemic challenges by providing adequate resources. We'll recall that one of the issues which has been a thorn regarding foster care is the issue of tools of trade, resources, and all that. So this clause will enable the functionaries to deal better with this particular issue if it is part of the bill that can be processed now. Otherwise, without it, the whole issue will not be complete. So it therefore it is therefore required in order to put in place the required child protection mechanisms and structures to maximize compliance to the entire Children's Act and thus deal with the issues that are not adequately resourced so that at the end of the day, there can be that completeness. Again, with regard to this particular clause, it looks at the establishment of the child protection units, which will strengthen the comprehensive social work assessments, which must take place in order to come at a decision at the end of the day that the child is in need of care and protection, and thus provides a response, prevention and early intervention services, thus minimizing the need for children placed under foster care. Clause 82, Honorable Chair, seeks to amend or to limit the placement of orphaned and abandoned children in the foster care scheme. So if that is effected, that limiting the placement of children into the foster care scheme itself will not be overloaded. There will be that kind of a limit so that at the end of the day, we don't have big numbers for foster care that will be a challenge. It therefore has to be read in conjunction with Regulation 55.1 of the regulations to this particular legislation in order to ensure the comprehensiveness of the legal solution that we need to achieve at the end of the day. Again, honorable members, still with regards to clause 82, it will also contribute to the comprehensive legal solution by addressing a symptom which seems to be a lack of comprehensive social work assessment, as has been indicated initially. So it will be looking at the systemic challenge through the establishment of child protection units by putting a specialized child protection model as a systemic mechanism for provision of child protection services. So such an undertaking will strengthen the social workers' responsibilities relating to sections 62, 155.3 and Regulation 51 as cited earlier. That is one of the critical children's court processes that is employed to determine if a child is in need of care and protection. Again, honorable members, still with clause 82, the indication is that an approach to limit such placement of children in the foster care system will also be taken into account that it does not infringe on the constitutional right of children, but placing children properly where they belong, whilst taking the burden out of the foster care system. So that's the modification that we are proposing in the comments that have been received. Will therefore put an additional control mechanism to ensure that such children who may be at risk, even in the care of family members, are not automatically excluded by virtue of relationship. So we will also be looking at that kind of a situation so that we address the comprehensive part of the solution. Again, still, and lastly, on clause 82, this clause will also complement the Social Assistance Amendment Act and its regulations, because you will remember that when the court ordered that the minister must introduce a law in terms of coming with a comprehensive legal solution to foster care, it's not only this legislation, it's also the Social Assistance Amendment Act that was passed in 2020, which looks at the top-up grant. So these pieces of legislation have to be read together. So this provision will in some way assist in terms of that, because it has to be read together with this particular legislation that has already been passed. Clause 83 will contribute to the decision-making process in relation to what I've just alluded to in clause 82. So it is more in the decision-making process, because it will contribute to this process in relation to clause as part of the comprehensive legal solution. In terms of section 155, we must remember that is 155 of the Act. There is a requirement that a social worker has to investigate whether a child is in need of care and protection. And because of that kind of an assignment, that assignment has to be construed in the context of clauses 82 and 83, because they complement each other. As I indicated in the beginning, that the manner in which we have to understand these provisions is that there is some interrelationship in terms of how they have to be implemented at the end of the day. Further than that, honorable members, honorable chair, when we look at clause 84, which is one of the clauses that we have identified as a collective, this clause clarifies the issue of caregivers within a cluster foster care, which will contribute towards the comprehensive legal solution, because it will minimize the confusion regarding the responsibilities of the caregivers as contemplated in this particular section in the legislation. It will therefore simplify the cluster foster care mechanisms that we deal with. And at the end of the day, it will promote compliance to the provision and diversify the scope of foster care services that support the comprehensive legal solution, and which also form part of a comprehensive cluster foster care regulations. The issues of compliance will also be addressed through this in terms of supporting clause 56 and clause 57 of the amendments, because there must be a compliance kind of mechanism that has to be put in place so that the system does not fall into pieces at the end of the day.
Excuse me, Advocate.
Okay.
Screen must say clear again once again only to other people what's happening. If there is nothing that they can see.
It's off. We should check to see if
And
the
I did
people
not
can.
share some documents.
When I are looking at the
Yes,
laptop,
yes, I was saying I did not pick
And
up
then,
that.
yeah, I didn't
Stop sharing.
until I was
What's your-
advised.
I'll stop sharing and I'll share.
Was it at this particular slide? Yeah.
Yeah, it's only that.
Check the people and
Until the end of the meeting.
Intombazana is phoning most nayo akayazi. Okay.
But that they
Can we adjourn also for a?
Recording stopped.
Thank you very much. Oh, sorry. Thank you very much,
Yeah, yeah, okay.
DGM. So we are really just highlighting progress with regards to the 350 grant in terms of the current iteration. Of course, you know that this is the third iteration that we are now.
That provides the services. So
Umama uPoltina nje isandla sakhe siphakamile.
I was thinking.
Chairperson. Chairperson.
But maybe they Yes.
Member Abrams? Member Abrams?
Hi, Lindy.
Can you hear us now?
I can hear you, yes?
Okay. DSD, can you hear us?
Yes, we can hear you.
Oh, can the stakeholders can hear us, just one or two of them, so that we can proceed? Are we audible?
Yes.
Okay.
Yes,
Okay.
thank you.
Okay, thanks. We're going to proceed.
You are muted, Lindy.
Okay, sorry. Can you hear me now?
Yes, that's fine.
Okay, thank you, Honorable Chair. We are saying we are on clause 84, which relates to the clarification the caregivers like care provision. Contribute towards the comprehensive legal solution was minimizing confusion regarding the responsibilities of caregivers. And at the end of the day, it will also simplify the cluster foster care mechanisms, which will about so to also promote compliance with the provision and diversify the foster care services that are supported by the comprehensive foster cluster foster care regulations, which to the regulations that support clauses 6 and 7 of the again, Honorable Chair, still on the presentation clause 85. So we are saying this amendment will provide another provision to address the mechanisms required by care for children that are orphaned or abandoned that may not necessarily require foster care placement. Because sometimes there is that condition where we say orphan child or abandoned child and are falling into the foster care system. Count this provision clarifying that if that's not always the case, then it will minimize the overburdening of the foster care system. It will therefore promote one of the children's actions that promote security and stability in a child's life by considering adoption, for example, as the first option, and not foster care as first option. Again, clause 85 will provide another provision to address the mechanisms that are required by caregivers to care for children that are orphaned or abandoned, who may not necessarily require the necessary foster care. Therefore, provide the legal mechanism that is necessary to think about the comprehensive legal solution. Clause 86, members, Honorable Chair, is one of the major contributory reasons the foster care challenges in terms of that result social workers non-compliance to the legislation to extend the foster care orders on time. So amendment of this clause will assist in bringing about the solution to that challenge. And this will result in the alternative care of children of right and that is not compromised. And then there are specific arrangements for social welfare and child protection with case when clause is properly implemented at the end of the day when it comes to provision. Second, clause 86 also enable the officers to be able to extend alternative care orders terms of Section 48 of the Act, already power to extend foster care orders of 6 months. So it augments that kind of a provision, so not as a measure, but as a measure that's already existing in terms of the legislation itself. Clause 92, honorable members, clarify the foster care provisions, also contribute towards the comprehensive solution to minimize confusion and diversify the scope of foster care services that are supported by the comprehensive cluster foster care and regulations. Also, understood to be one that will assist us in terms of compliance with the regulations that are supported by clause 56 and also clause 57. Again, honorable members, honorable chair, we have clause 93, the one that was when I was saying, since we have dealt with clause 1A as a new insertion, which was not in the previous matrix that we forwarded, there is need to read it together because it will apply in the operation of the cluster foster care in relation to the clauses that we identified clause 1, that is the sub-clause 1A, and must also be read in conjunction with clauses 4 and 92 as part of the comprehensive legal solution. Again, clause 94, must also understand that part of challenge experience with foster care relates to periodic 3-year extension of foster care orders. Presiding officer attends about 8 orders. So, in terms of the that are scientifically and okay, and the child attends, that in turn increases administrative benefits of us, and that carries further of orders lapses the systems challenge. So if these challenges are dealt with in terms of it have to be particular points, then at the end of the day, this would be dealt with one having the challenges regard to the 2-year extensions and all that. So this again relates to the reluctance that arises from the lack of supervision of foster care placements of children in foster care by social workers. So once we enforce Section 4, once it becomes a law, it we are of the view that it take away that kind of reluctance, so that at the end of the day, it was that we are looking for. So it will also strengthen Section 186 provision, and therefore will create the right issue more Section 186 order to less order higher extension of foster care. Again, with regard to clause 94, we must also understand that there will be strengthening of Section 186 what we have related as far as and 57, which seek to make a provision for MSCs to establish well-resourced quality assurance, which will contribute to the comprehensive. So it's a question of ensuring the existence of quality assurance, which at the end of the day assist in ensuring that burden does not become too much at the end of the day. Work is not left to pile up, and orders are not left to pile up, so that there's a challenge to a backlog. Put us again, honorable members, with also strengthening that is the stage of prevention and early intervention services, therefore minimize the need for children in foster care, because once prevention mechanisms, early intervention mechanisms are put in place, children not we are saying, honorable members, we will comment to this committee, takes note of the information, and also takes note that we also have Annex A and Annex B in part of this proceeding. And Annex A bill that is chief talks to this person. So it has to direct so that to see how like in long run, and then of amending when there is a need for amendment of those clauses later, but just the kind that we look at the end of it. And the Annex B looking at the best that for such a clause case metrics provided those 1A and also clause 92 were not metrics that developed. So basically, that is the position with regard to clause honorable chair. I'm not sure whether we must proceed to look at how it looks, what it and then take the questions and or your message. Thanks. Thanks.
Thank you very much.
Yes, Chairperson.
Are you able?
So you are very faint, Chairperson, but I can hear Lindy. Can't hear anything now.
Hello. Alex.
Yes. Like I say, we can hear you, but it cuts and goes. Lindy seems more audible.
Honorable Akram,
Yes, Chairperson.
hello,
Yes, we can hear you, Chairperson.
Clara. Hello.
Yes, we can hear you.
Okay, can you check the state law? Can I think of you? Yeah, I didn't want to. That's you. State law advisor.
Morning, colleagues. Lisa from the Office of the Chief State Law Advisor. I hope you can hear me. Morning, members. I just want to confirm that together with the parliamentary law advisor,
Okay. We are going to put you on now. Because other members. We deal with our. Thank you. The only one. Thanks, Chair. Okay. Yes. Alex.
Chairperson.
Will you be able to type please, I do. what she was saying?
So yes, I was able to hear Miss Liz
Oh,
Knight,
you were able.
and I can
She
hear.
told us. She told us. Yeah.
However, the audio from the room you're in does cut now and then.
Okay. There told us just for look let's pull it rather up and fold over. Fold. Dollar. That's it. Okay. Hand. Okay. I think what we can parents in satisfying of, but I think we're in a stalemate now where even if it's solely trust vice versa. I think from a perspective of having that what we wanted to do, clarity close it for the satisfy. Yeah. What is for us, I think we've made progress. I think on the next today, maybe but I think now I'm very satisfied with when I said that, but I cannot answer. But I think from a course perspective, these 12 clauses satisfied our question last week was 1, 5, and 12. And I think the argument is well made what we should do. But I think by we cannot go through that because we've not yet. I'm not going to. Okay, can I again? They'll have thanks the department. I'm also happy because they met three of them parents advice. Then when this one of I can not what we are saying. I was saying for the example that we are looking at the website. It's asked us to diagnose, but one big diagnose. Because other the stakeholders don't so that person if I may say that maybe let's have the meeting where all of us can be together so that this thing there should be followed by a letter that we didn't hear, but let's make sure I'm to power that vested on make sure that we must one where the hybrid will be able to accommodate those stakeholders that legal and one thing. Another. Okay, it's there. So we are not going to no, buy it. No, no. Actually, I want yes. Okay. Yes. So we will use it for our so that one yeah. Otherwise, one entire might not be. Say something. Anyone it is done. Bonita, yes, Bonita, are you with us?
Yes, Chair.
Are you able to hear?
I'm the whole time in, but I can't hear anything. It's the first time I hear you people are talking. Hey, this is bad today. I thought last week was bad, but I think today is even worse.
What's now?
Can you hear me, Chair?
Yes, I do. So where are you? Now. Are we going?
So, right. Okay. Now that the committee has taken a decision to adjourn the meeting, especially to deal with the foster care issues due to the technical glitch, but the committee can proceed with its internal businesses, that can, so if it can make decision. And currently we are a quorum, we can proceed to adopt the committee report on the APP of DSD, its entity, as the debate is scheduled for Friday the 13th. So we need to have the report adopted and being ATC tomorrow so that you can be able to debate and it becomes an official document. Last week also, there was an issue of the revised second term program. It's also an internal business as this committee, which is a quorum, can proceed and adopt those two documents on today's in this meeting. So I just wanted to request through you, Chair, that at least these two documents can, because we're a quorum.
Only
Are you saying, Chair?
are you?
I just heard they talk about cancelling the meeting because of difficulties. Your sound is very, very bad, Chair.
I feel like when I was 6 years.
So first, for us, we are done. Very much.
Thank you. Are you? Only.
Chair, I still can't hear you people properly. You're breaking up all the time.
But were you able?
Sorry, Chair?
Were you able to hear Honorable Song?
No.
Onita?
Yes, I cannot hear. I hear Letitia, I can hear you there. Yes, now.
Onita, where am I?
Ek hoor jou, Letitia.
Kyk, jy staat hier, daar's 2 items op die agenda. Die een is die second term se program wat ons moet adopt en die ander een is die report vir Vrydag se debate. Hoor jy my?
Ek hoor wat jy sê, ja.
Omdat ons 'n probleem het met die sound.
Ja.
En ek weet ook nie hoekom jy net my kan hoor nie, want dit is net die EFF wat jy kan hoor, maar ek sal jou maar sê. Dan moet jy is die enigste een van die komiteelede wat op die virtual is. So ons gaan want
Dis kas julle maar dan kom dan gaan ek en jy later
ja,
pas
maar
ek
ek
kan
het
sê
jy
wat
so
aangaan.
dat jy kan hoor is reg.
As reg ja.
Ja,
Dan praat
okay.
ons dan later
Okay,
as reg.
reg, dankie.
Ja, dan gaan continue.
Okay.
As reg. Okay dan. Sien jou.
Ek sê wat maar ek wil vir jou wat. Dis al wat ek sê. Dis nie en dit is wat ek so Babaat. This is a bit that's so because you might know why. Thank you very much.
We adjourn our meeting. There's no sound. Adjourn. We're gonna try to source venue outside Parliament. And I want to for you to set up the hybrid there for checking. Okay.
Yeah, more than enough. Take another point. I must go write the ANC members for PFA. Yes, Patty.
I think I must log out and you can continue with your meeting because it seems like I'm the only option now.
Okay,
but it looked like the social development only had a reunion today.
The horror movies, man.
You people called the reunion today to see each other. Ek sê julle het 'n reunion geroep vir vandag.
Kwendezenza ukuthi si-applyele sihlale hotele parliamente ikhuphe imali.
Yes, yeah. Yeah. Here, as a reunion for the very back here. Yeah, I'm going to okay. All right. Yeah.
What give us the what way forward?
Yeah.
Way forward. Oh. We do the next item, which is are you ready?
Azokwazi ukuthi kaloku awujonanga the updated one.
So on this is only a bit of it.
Recording in progress. Recording stopped. Recording in progress.
Okay. And I'm gonna go through the report and at the section that maybe members need to get into or are more important, because the other sections were just taken from the analysis that were provided to the committee before we the report. I think went through the basically what the department purchased in terms of APT. But I think just to go quickly, some recommendations that were made by the Office of the Auditor General. Okay. Under the discussion in section 2, maybe I can read them. I'm using a that I'm not. Okay, the AG had made a few recommendations to the committee that we should make a follow-up. First one was that we must follow up on the progress of resolving the material irregularities, actually taken ensuring that to not continue. It will hold the department and its entities to of how the taxpayers' money is used. It takes always within the machinery of government and public agencies. Thus, it can improve the efficiency, economy, and effectiveness of government. Because it's not showing pages. It's 6. Oh, okay. Okay. That's above 2.1. Yes, all right. And the next one, determine what action or consequences have been taken because those responsible for the material irregularities. Also, that oversight over the filling of vacancies ensure stability of leadership. Also conduct oversight over the implementation of action plans findings. It should also enforce the culture of management in the social development portfolio. Monitor and follow up on the progress of the civil databases on a regular basis with the monthly validation that the risk of payment to eligible applicants. We should make a follow up on appointment of the NDA board in terms of the NDA Act. So I thought I should highlight this because at the end of the report, I just included a section where I identify the key areas that emerged as the committee was discussing, and also was going through the agencies that are thought they're important for the committee to focus on in its oversight, which this one is one of the chair. These are the recommendations that we make to the committee. So then it means we must then as a committee act on it. So that should highlight this section, chair. The other sections that I think are important deal with the deliberations on each of the presentations. Other sections then at the end, it's the recommendations I formulated based on deliberations. And then the last one, like I said, is those areas that identified as key focus areas. So basically, that's how the report is structured. So if you allow me, and then should I just then present as I have just alluded, or you want to go through page by page? I need to be guided. Okay. Oh. Okay. Unfortunately, Chairperson, on the same page 6, I request members to guide me because I don't see huge numbers on this one. There are deliberations that the committee made on the Auditor General's presentation. Yes. So
The first one, I'll read it as it's written here. The committee, okay, what happens is there are certain issues that you raised prior. So then I will then use that you reiterated on those concerns because they also raised them during this deliberations. So the committee reiterated its concern over the lack of consequence management and that officials are not complying with the necessary policies and regulations. Lack of consequence management is demonstrated by the fact that some of those implicated are no longer working for the NG. It also noted with concern the AG's findings on vacancies in critical positions and the serious implications. Oh, I tried my computer to correct things of that on the functioning of the institutions. I think I was saying, sorry, sir, sometimes I have things. Okay, we just read it again. Also noted with concern AG's findings on vacancies, positions, the serious implications that they have on the functioning of the institutions. It also noted with concern the AG's findings that at SASA, some officials were appointed who did not have qualifications. It also noted the concern raised by the AG regarding weaknesses in the IT security management of the department, which may leave it vulnerable to cybercrime. It sought clarity on AG's view of the status of the preventative controls at DST and its entities. Are there any that are still outstanding? Are the preventative controls contained in AG's performance management as well as employees? Does the AG keep a dashboard on the recommendation it has made and findings of controls? Here, what I did, I put the declarations and where there were explanations given, then I all right. The AG explained that the preventative controls that were previously reported on related to COVID-19 measures, and many of them have not been fully implemented. That is with that. The next one, the committee also noted the concern the findings of the AG made on the MI, that would be material irregularities, particularly relating to the payment of 350 as a grant to ineligible beneficiaries. Wanted to know the extent of the material losses had and to what extent this was due to adequate controls. AG explained that SASA management is of the view that adequate controls have been put in place, but based on audit controls, this is not the case. SASA is operating in a paperless environment, and that makes the administration and payment of challenging. SASA used older databases which led to overpayment in some cases. Databases are not always accurate and complete. Also, SASA only receives databases for a particular month, 2 months after it has made a payment. It is important, therefore, for SASA to still conduct its verification. It should also use as many databases as it can to try and identify ineligible candidates. Beneficiaries. For example, it can also verify using banks databases. A means test is another important method that can be used, and it must be done by the banks. It can also use the National Student Financial Aid Scheme, NSFAS in short, and Unemployment Insurance Fund, UIF database. The next one. In 2021, over 200 million was lost on the payment of SRD grant to ineligible beneficiaries. It still needs to be established what the potential amount was lost between August 2021 and March 2022, as well who the ineligible applicants are. The next question, the committee also wanted to know what is the AG's view on the development of outcome indicators by the social development portfolio. The AG reported that the 2022-23 performance information shows that there are technical indicators and targets that should be linked to the mandate of the department and its entities. During the audit process, it reviews whether there is alignment between the audit process and what is contained in APP and the legal mandate. It advised the committee to be involved in the planning process. The committee should ensure that the said performance information is within the ambit of issues considered critical. Okay, so that's the deliberations on the presentation by the Auditor General. Should I pause here to take input and then go to the next? Or should I just read all of them? Okay. 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 Honorable speakers, when I because the system, remember there was load shedding that day, so I was out on some days. But when I listened to the lady recording, we listened to the recordings. There are certain questions that two chairperson draws that will be answered by the department. And I remember this one was one of them. So it's covered somewhere in the responses from. But if it's not articulated, please let me, then I can do that. Same as yours, Mama Paris, 2,000 jobs within NDA, it's that the okay. Yes, 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 because yes, this question, some of them were raised during the deliberation, but they made a ruling that said they are not for the age. proceed then to the deliberations on the presentation from DSP. This was from the age. Okay, and that is on page 22 under section 6. Yeah, sometimes they change, I think, depending on the structure. On page 22, section 6. Okay. I'll take the first one. The committee reiterated its concern over the continuing vacancy in the position of the Director General. When will it be filled? It was equally concerned about other vacancies in transport, particularly at senior management level. What are the budget implications of these vacancies? The committee raised the same concern over the past 2 years. The department explained that with the budget cuts, especially on the position of had to embark on prioritizing of the department had a budget cut of 495 million, and that has resulted in it not being able to fill all the vacant posts. Yes, then the next one, the committee yet again expressed its concern about the continuing shortage of social workers. And yet there are many social graduates who are unemployed. This was clearly demonstrated by the social work graduates who protested in Barcelona over their unemployment. The committee wanted to know how many social workers were employed in the 2022-2023 financial year. The department reported that it was engaging with a number of relevant government departments on the employment of social workers. The plan is to develop a joint to engage the departments, which will be finalized in July 2022. There is currently no budget for the employment of social workers. However, provinces have been engaged to extend employment contracts of social workers who are employed on contractual basis. The department is also conducting an audit from provinces on how much capacity they need. There has been a refrain from National Treasury from funding employment of social workers. It has advised that department relook and reprioritize its compensation budget. Next question, the committee sought clarity on the 207 social workers trained on the adoption policy. Will they be newly appointed social workers or employed social workers? The department explained that the social workers who have 3 years and above will be trained on the adoption policy. It sought clarity in the committee sought clarity on how the social relief officers would be implemented as part of the Social Assistance Act when it's not legislated in the Act. The department reported that it had drafted regulations on the payment of the grant. It was waiting for concurrence from the National Treasury. New regulations were implemented in May 2022. The next one, the committee reiterated its concern regarding delays in finalization of investigations of irregular process and wasteful expenditure, particularly at SASSA and wanted to know the reasons for the delays and whether the implicated employees are still working for the department. If so, what risk does this pose on the department's payroll? It also wanted to know what is the department doing in real time to address the delays in investigations on irregular process and wasteful expenditure. What progress is made on outstanding cases? Are there any key performance indicators for senior management regarding finalization of this? The department explained that in all performance agreements of senior managers, there are aspects of how issues raised by the AG responded to. With regard to challenges at SASSA, the department holds regular entity oversight meetings. Importantly, it's in the process of finalizing amendments to SASSA Act, which include provisions for the establishment of the board. Okay. Committee further wanted to know what are the 9 districts the anti-gangsterism strategy is planned to be implemented. The department responded that the 9 districts are Western Cape Metro North, Sedibeng in Gauteng, eThekwini South in KwaZulu-Natal, Francis Park and Harib in the Free State, Khar Sibande in Mpumalanga and Vembe in Limpopo. With regard to the department's plan, 92 municipalities on how to integrate migration into the integrated development plans, the committee wanted to know if the department has a clear plan to train municipalities on. Migration has presented municipalities with a lot of challenges. That is sprawling informal settlement, the need for basic services, and government social assistance. This question was not addressed. In reference to the AG's concern regarding weaknesses in the department's IT security management, the department unable to stop at time, the committee wanted to know what mitigating plans in place and the exact cost. This one was also not addressed. Does the engagement with the department's chapter? Oh, that's the thing. And then I don't have for the social work policy. So it's not clear how much talking about filling of the social work positions. No, yes, ma'am. Mm. Amen. Okay. Okay, I've captured it, Mama Jane. I'm just gonna write it nicely later. Okay. Okay, can I proceed? Okay, to Sasa. That is on page, section 8 on page 24. Oh, 29 on 9. The deliberations on Sasa. Okay. Yes. Section 8 on page 29. The committee wanted to know how quick was SASA's response to the natural disaster that is flood in KwaZulu-Natal. SASA responded. SASSA responded that the disaster relief team had been deployed for a few days after the flood and had distributed vouchers to 1,500 people who qualify for the relief. There was no additional budget allocated as this was part of the normal relief allocation. Okay, with the consistent high levels of fraud and corruption in the grant payment system, which also involves SASSA and SAPO officials, the committee wanted to know if SASSA ever considered doing an overall rating of its officials. This can be one avenue to eliminate fraud and corruption. SASSA reported that it holds regular meetings with SAPO and receives cases for reimbursement. SASSA has also been working with the fusion centers, and that has made a difference in the fight against fraud. I'm not sure the fusion centers are. That's what was reported. Because SASSA is not a bank, it is not in charge of payment cards, but with the new appointment of post-based CEO, it is hoped that this challenge will be addressed. With regard to the relocations of the cost management center, the committee wanted to know who the new service provider is and the reasons the previous one could not continue with the work. The question was not addressed. With the challenge of many new mothers not being able to register their newborn babies for children's rights and long offices, the committee wanted if SASSA could consider implementing pre-registration at health facilities as a way of government services. SASSA explained that the challenge is that mothers often do not have the required documents whilst they are still the facility, even though it provides information pamphlets to health facilities. There's also a challenge of misunderstanding of the test for child support, where people think they do not qualify for the grant because they earn income. This can particularly be observed in more urban areas where people are employed on a part-time basis or occasional. There is a need for more information dissemination. The committee wanted to know what progress has been made on SRT grant appeals, as there is a lot of people waiting for the outcome of the appeals. SASSA explained that it has not been able to attend the appeals start in August 2021, and the numbers are fluctuating. Delay is partly due to delays in finalizing contracts with the banks for 2023 financial year. SASSA has amended the application process for the grant as with the end of the disaster management period. The grant will be paid as part of the social assistance package. Also, appeals will be dealt by the appeals tribunal. Regulations for the new processing of the grant were finalized and submitted to National Trade. There are people, around 300,000 for the first cycle, who have not collected their grants. SASSA has sent messages, that is SMSs, reminding them to collect their monies. As a result, there has been an increase of people collecting their grants. The committee also wanted to know if SASSA can determine in this system the ages of mothers and place them in your program. It expressed concern on the possible impact of closure of SAPO branches on the payment of social tax. It wanted to know if SASSA has a contingency plan. SASSA reported that there is substantial budget amounting to 19% of its budget allocation to key items within the services that go to SAPO. There is a continuous monitoring of the adherence of its level agreement with SAPO. When there is non-compliance with the SLA, penalty is charged. For instance, 17 billion was deducted in 2021 budget allocation. I think that was your question, Mama Sukas. SASSA has a contingency plan should SAPO not be able to deliver But it's important to note that minimal amount of clients, 500,000, use SAPO as payment option. Therefore, the numbers are likely to be affected upon a minimum. The committee sought clarity on the target to use pay points and what impact it will have on beneficiaries. SASSA explained that the reduction will be done in a number of ways, such as relocating the pay point to a better resource pay point or to rechannel beneficiaries to other payment channels. The committee also wanted to know what progress has been made on the implementation of the organizational change the Director General reported on in 2021-2022 financial year. What has been this tangible outcome? SASSA explained that the process is planned to be rolled out for 24 months. Officials were trained on it and evaluation was conducted and reports received for the culture and mindset change. A detailed operational plan can be forwarded to the committee. The next question, committee expressed a concern that even though at the beginning of the current administration, a commitment was made by DSD that there will be new social development sector. Thus far, there has not been tangible outcome or impact demonstrated by persistent low at SASSA offices. And nothing was addressed there. The committee also expressed a concern over the challenges of overcrowding at the population of SASSA office. SASSA explained that there have been around 4 or 5 informal settlements that have met around the area. This happened when some offices in the area had to be closed to various dangerous social issues. The challenge has also been non-compliance to and safety standards in some offices, such as Mrs. Spain, Kailicha, and Portugal. These challenges have resulted in overcrowding in neighboring service offices. SASSA has engaged with the Department of Public Works and Infrastructure to open 2 additional offices. The issue of populated office is a matter of priority. The committee also raised a concern that in George, there are no doctors to assess applicants for the disability card. SASSA explained that there was a lack of science assessment doctors, but requested to be forwarded with more details. Okay, Chair, that was for SASSA, Chairperson. Can I proceed? Okay. Yeah. Oh. Sorry. So you want to raise it as a concern? Okay. But you can vote and then I'll write it nicely. Okay, I'm proceeding to the NTA now. All right. And the deliberations are on 32. Yes, under section 9. Section 9, that's page 32, 36, and the section is 9. The committee reiterated its concern about the lack of visibility and impact of the NGA. For instance, can play an important reducing the 47% of people rely on social grants through its programs, thereby fulfilling its mandate. NDX explained that its impact and visibility has negligent due to the previous service delivery model that did not have any impact. The committee was equally concerned that 7%, that is 28 million budget, goes to the compensation of employees when there is a serious lack of its impact. It is also despite the 7 million budget for travel and subsistence. It seems as if the NDA is just a channel or a conduit funding goals and not mandatory. The NDA explained that its budget structure may look abnormal, but according to Section 3, Subsection 2 of the NDA Act, the budget allocation to the NDA should be for operational costs. Section 3, Subsection 1 of the Act provides that the NDA should raise funds for funding from the donors. The NDA has not made a strategic move on how to implement Section 3, Subsection 1. However, the general strategy seeks to address this. Furthermore, the resource mobilization unit has been established to mobilize funds for the civil funding. Currently, the NDA is only allocating 14 million per year for SCO funding, and that is not enough. Furthermore, the budget cuts have had a catastrophic impact, as demonstrated by the 7% budget allocation to COEs, compensation employees. This has made it difficult to implement the core mandate. The reason given by National Treasury for not increasing budget allocation of the NDA has always been that the ESD has to reprioritize and do a function shift to the NDA so as to allow more funding and implement its core mandate. This has not been done by the department. It is one of the reasons that the agency decided to formulate a standalone strategy so as to attract funders. It has also decided to fill some of the vacant posts, otherwise, had it not done it, would have been rendered useless. It was going to have a very high CO budget with much less budget. Next one, the committee also reiterated its concern regarding lack of consequence management, those implicated in the irregular and fruitless expenditure. We wanted to know what measures has the NDA put in place to recover monies withdrawn. NDA explained that 1 million irregular and fruitless expenditure dates back from the previous financial years, and unfortunately, it has never applied for condonation. For it to obtain a condonation, there should be some requirements that have to be met, such as determination of financial loss. Some of the cases involved procurement of office space without following SCM, and so there was no sufficient financial loss. The agency is currently investigating a 15 million irregular and fruitless expenditure, and depending on the outcome of the investigation, it may recover it. The committee wanted to know when will the vacancy of the seat going to be filled. The NDA explained that the recruitment process for the filling of the CEO and board vacancy has been completed and submitted to the Minister for approval and forwarded to Cabinet. At the end of April 2022, there should be an appointed board. This is the date that the NDA had agreed with the Minister. The appointment of the CEO processed by the new board The committee also wanted to know the deadline of the implementation of the turnaround strategy and the costs associated with it as an external service provider was with. The NDA reported that the deadline for the implementation of the turnaround strategy ends in 2022. The service provider was appointed for a period of 12 months, May 2021 to April 2022 at a cost of 4.5 million. The committee sought clarity on how the 3,000 work opportunities for youth implemented and how much stipends would they receive. The NTA responded that the work opportunities would be implemented from various programs such as the volunteer program, 2000, UIF, and grant funding program. The agency works with CS to create opportunities. With the UIF, it went through a competitive bidding. With program volunteer, it issued a request for proposal. With grant funding, it issued request for proposal and proposed that formulation where NTA supported community to develop the The committee also wanted to know to what extent the funding of SOs will be affected with the medium-term budget cuts. Also, how the NTA is supporting SOs to raise to fundraise. The NDA explained that it supports CSO through its capacity, through its mandate of capacity building. The committee also wanted to know how the NDA plans to support food generation projects, particularly in the context of increasing food prices. The NDA explained that it supports and funds food kitchens, also known as Community Development Centers, CNC, and also by assisting them to start vegetable gardens and poultry. The committee also wanted to know what progress has been made regarding the allegations of corruptions that were made against the previous CEO. The NDA reported that National Treasury only approved the interim accounting officer at the end of November 2021, and the office immediately appointed investigation officers. They were given 60 days to complete the investigation. The report will then be provided to the whistleblower. If there was mismanagement of monies, the case will be referred to the South African Public Service. That's the end of the deliberations today. Covered. Okay. I can see the smile in your face. Okay. So where I need most assistance is down the recommendations. I draft them using the deliberations that the committees or the observations made by the committee. Okay, with regard to the department, I'm on section 10 now, members on the same page. I just finished off the preparation. The minister should ensure the department within the 2022-2023 financial year fills the vacancies in critical positions, particularly that of the secretary. Minister should ensure that the department within the 2022-2023 financial year puts in place systems to ensure its IT management against the firewall, so as to protect it from cybercrime, which is also with the advent of COVID-19 pandemic, the department and its entities had to implement most of their services digitally. The minister should ensure that the social development portfolio within the 2022-23 financial year addresses all the findings and recommendations made by the Director General and reports to Parliament on progress made on quarterly basis. Parliament in brackets. That is for the USD. For the salsa, yes, ma'am. Okay. I think also. Okay. 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 Can we proceed? Okay, yes, my check. You have put the touch, and I will then go for a member go up to the deliberation and that is a type in with just let me know. Okay. Okay. Just Yeah, thank you, Kat, because just sustained it because this is a report on APP and what was presented in the deliberations that ensued. But I suppose as we then committee may, I don't know, the opportunity here. I don't know. We think about it.
Maybe even ask the department to come and present.
To come and present
As part of what you're sorry. Which is another way of exercising oversight on matters where you think is of importance. The committee has a right to request the department to come before it and present whatever subject matter they deem it necessary to do so. Maybe we can try to allocate a slot for the department to come and present the plan of social work. Thank you.
I think to the recommendation whatnot. Sorry, I just have to back as a concern. Honorable Lizzie, on an average just raised. Okay, now I'm on page. Okay, now the pages I've shifted on my side. I've just added some notes. I'm on page 40 now, Chairperson. 39 on the report, yes. 10.2. Okay. The minister should ensure that SASSA within the 2022-23 financial year addresses the ordinance funding on inefficiencies in the verification process of SRT grant beneficiaries. SASSA should make sure that it uses updated databases prior to making social grants payments. The minister should ensure that SASSA within the current financial year investigates and take action on the ordinance findings that some of its officials were appointed without qualification. The minister should ensure that SASSA implements or strengthens its human resource policies on vetting and academic clearance of its employees as one of the measures to prevent fraud and corruption. The minister should also engage with the Minister of Communications and Digital Technologies on the same matter for those employees who work within the social grants payment system. The minister should ensure that SASSA expands its information dissemination on the pre-registration of service health care for children's social grants applications. The information should be disseminated through other channels such as media, inclusive of social media and mainstream media. The minister should ensure that SASSA within the 2022-23 financial year finalizes all appeals on SRT grant, including those dating back to 2021. That's now the SASSA community that could come up with. Proceed, Chairperson, to 10.3, which is the NDA. On the same page, Chairperson, the minister should ensure that the NDA within the 2022-2023 financial year fills the position of the CEO. The minister should also ensure that within the current financial year, the NDA board is appointed. The minister should ensure that the NDA board within the current financial year conducts and finalizes investigations on the allegations of fraud and corruption against the previous CEO. I thought I should put that as a recommendation, even though it was reported that it's going to be done. So make sure that it's done. Okay, on section 10, as I explained earlier, these are the areas I thought I should highlight as the key focus areas identified as I was drafting the report and going through the preparations. So based on the APPs and AG's report presented to the committee and committee preparations, the following are the key focus areas of oversight for the committee for the year. Implementation of AG's recommendations. So the committee reported on this report on page 6. The development and implementation of the joint by DST to engage other government departments on the employment of social workers, which is to be finalized in July 2022. I suppose it can tie in with the suggestions that there must be action plan tabled in Parliament. The working relationship between SAPO and SASSA with regard to the implementations of the SLA, particularly the possible risk of SAPO financial challenges and closure branches on the payment of social grants. The committee may need to be briefed on the contingency plan SASSA reported it has to use in case SAPO fails to deliver. This is an important oversight area for the committee as SAPO accounts for 19% budget allocation of goods and services. The implementation outcome and impact of the organizational change at SASSA, implementation outcome and impact of the turnaround strategy at the NDA, the budget allocation structure at the NDA as per the provisions of the National Development Agency Act, how the new service delivery model and turnaround strategy address this challenge. It's another critical focus area as it significantly affects the funding of festivals and ultimately the implementation of the NDA's core mandate. In relation to the aforementioned, make a follow-up on the advice by the National Treasury of a function shift from DST to the NDA that will allow more funding of the NDA to implement its core mandate. And the last one, Chair, progress on the investigation on allegations of fraud against the previous NDA. That's the Chair. Okay. Biometrics.
Okay.
Mm.
Mm.
Mm. Yeah. Okay. I think it can be because it speaks to the concern that the committee raised about the risk of the SAPO branches closing and impact on the payment of grants. Yeah, so it is here. So a recommendation can be made. Yes, Chair, I'm trying to get my mind how I can draft it. Yes. Thank you. Yeah. Mm. Yeah. Mhm. Mm. Sorry, sorry. I'm struggling to come up with a recommendation on this one. The one about something about that so now the announcement, sorry, I missed it, ma'am. The announcement was that SAP will no longer be paid by SAP. Okay. So we need to find a way that would link the SLA, like Mama says. What about it? Sorry. Yeah. Can I just ask the you can assist me? Can we then put that as a resolution of the committee in the minutes instead of would that be okay? Or in minutes of minister coming to the committee about the
resolution.
Yes, made resolution, yes.
About the closing down of the post office.
No, not continuing.
Pulling away, sorry.
The latest.
Oh, the 350 part.
Yes. Okay. All
SRT.
right. Thank you.
Choose benefit.
Yes. Share to the committee. Go ahead. The program is in the media. It's in the program.
No, I said it myself.
Where are you? I'm saying. Yeah. Okay.
Committee programs.
I am not. Yes. Okay. Okay. It was not. Fine. Yes. Yeah. No, they can't pick up the Okay.
I just wanted
No. Honorable Masango.
You not.
One that say
Oh, shit. But this time around,
Honorable. Okay, wait. Yeah. Okay, who put seconds? Thank you. And then next item. I sleep.
you right. Thank you, Chair. As the committee suggested in our meeting last week, that we need to table the revised program for it to consider and adopt. We have done that with the chairperson. Chair and members, today we were supposed to deliberate on the Children's Amendment Bill, the foster care clauses, and well as to adopt the report on APP and the community program. And next week, the 11th, unfortunately, we haven't done the foster care deliberations. So next week, we're gonna start with the deliberations and inputs on the Children's Amendment Bill, which is the foster care clauses. On the 18th, Chair, yes, next week, on Wednesday. We will try to apply outside Parliament. Fungile is busy with quotations. I'll submit the applications to sit outside. We're supposed to do the A list, which I don't think that is possible. It's gonna be in the hotel, maybe by conference room. We're gonna check that, get 3 codes. And then we are supposed to consider the A list after our deliberation. So today's decision will have an influence in the program going forward. Chair, on the 25th, we're supposed to adopt the bill. I think on the 25th, we will have our A list. If time permits, what we can do with Umjengane is to also look at the B version if the committee agree on the amendments. So we present the amendment list as well as the B version at the same time. And then at the later stage, the next meeting, which is the 1st of June, Chair, we're supposed to do the briefing on the new regulations on the payment of social relief of distress, as well as the consideration. Yes, Chair. And then, Chair, on the 25th as well, we were supposed to have a presentation by the content advisor. If you recall, members, there was a fundraising amendment bill that was presented by DTG, Brenda Sileko, where the department consolidate the 5 dormant accounts into one account. So we advertised that bill. We received only 1 submission. So it's just a technical bill. So because of the change, so it's going to be on the next date. Maybe you can put it on the 1st as well. And then the 8th of June, members, we will deliberate on the input of the fundraising amendment bill. As well, we received the briefing on the DSD and its entity on the 3rd term quarterly report on the financial and non-financial performance 2021-2022. So this is part which informs the BRRR that the committee needs to consider the Section 32 reports, which is the quarterly report, so that by the time we get into BRRR, all the quarterly reports have been considered by the committee. And then on the 15th, members will consider and adopt the B list on the, I think it's a typo, on the fundraising amendment bill, as well the presentation by the content advisor on the 5-year strategic plan 2019 to 2024. So members, because of today's decision, some of the activities might fall over to the next quarter, but I will sit with the chairperson and get advice as to which items that might fall away. But in our discussion, maybe the chairperson will guide those that are of priority, like the SRD, new regulations, etc. So I think in 2 weeks' time, members, if there are no other challenges, we will finish the children's amendment bill so that it can go to the NSOP. Can I have a Okay. Yes, we advertised on the national, regional, and local newspapers. Yes, so it came through that public through that newspaper publication.
Yes.
Mm.
No. It was
And then Children's Cup took over, and we went to the provinces.
I just need
Can I respond? Okay. Can I try? I will respond to two things. One from Umemba Masango, and then one from Umemba Sukaris. Firstly, the process of the bill, when the executive tables the bill to Parliament, they have their own process of gazetting and whatever, and then they name the bill as the Children's Amendment Bill, and then the bill goes to the joint taking mechanism where Parliament will sit and look at the Speaker whether to take the bill as 75 or as 76. So this bill has been taken as Section 26 bill, which means that it's been introduced to the National Assembly, and then after we've done with our process, it will go to the NCOP and then to come for concurrence. And then now the motion of desire in the process after we've consulted the stakeholders as the Constitution requires us to do so. And then we find and we satisfy that we need to proceed with the bill. As the MOD, it's a certificate for you to go to clause by clause as we are doing now. The decision, the committee in the process of that, after adopting the MOD and then they just prioritize the issue of the court order. There's nothing wrong with the MOD that you adopted. It doesn't change because we say we deem this bill fit for the committee to consider and pass so that it can comply with the court order. So we are still driving with that MOD, even though we said we want to only consider the foster care clauses in the Children's Amendment Bill so that we can comply with the court. The name of the bill will remain as the Children's Amendment Bill as tabled and introduced to Parliament by the Executive. Now that it's only the amendments that we are concentrating on the foster care clauses, up until the end, it's going to be the Children's Amendment Bill, Bill 18 of 2020. And then in our report, we'll express as to this particular day agreed to take a decision to only consider the foster care amendment. So there will be no new MOD being adopted in the current bill that we're at. There will be a new name change, the bill as introduced by the executive. Because if we change the name, there should be that process starts from the scratch, and then the executive must go and gazette. They must go to the cabinet and table this new bill. It must be approved by the cabinet. There must be a certificate of the bill by the legal advisor. It must come to Parliament. Parliament must do their own processes. So for now, we'll proceed with the Children's Amendment Bill as introduced to Parliament. What will happen now when we do the committee bill? Because after we've completed the process, our legal advisor will draft a new bill, which is maybe there'll be a Children's Second Amendment Bill. So that outstanding the clauses that the bill didn't consider, it will be contained on the Second Amendment Bill. That one would be, the process will be shorter because the Constitution complies as to advertise. We will advertise national, regional, and community newspapers are requesting input. But we know we will have our input. So, and then we'll go to the MOD again on that particular bill that is drafted, committee bill to be drafted by the legal advisor, and then we'll consider a thick document when we consider the clause. That would be the process. Thank you. Okay. Yes, on the line. Yo, other 2 years.